Greetings everyone. Today we are going to discuss on the subject jurisprudence, and this is Ms. Saloni, Assistant Professor, IIMT College of Law, Noida. The topic of today's lecture is the status of persons in jurisprudence. Coming to the introductory part, personality. Personality begins with birth. When a child is born alive, he is considered to be a person in the eye of law. In Hindu law, a child in womb is considered in existence and he inherits the property if he is born alive. If a partition takes place amongst the four partners, a share is to be reserved for him. If the share is not reserved, then the partition would be open and the newborn boy would take the same share which he would have taken if he was born before the partition. If a pregnant woman is awarded death sentence, the execution of the sentence shall be postponed till she is delivered of the child. Abortion and child destruction are crimes. Next, I would like to come on the definition clause where Salmon, the most famous thinker of jurisprudence, elaborates. A person is any being whom the law regards as capable of rights and bound by legal duties. On the other hand, Savigny defines the term person as the subject or a bearer of a right. According to Austin, the term persons includes physical or natural persons, including every being which can be deemed human. According to Section 11 of the Indian Penal Code, the word persons include any company or association or body of persons, whether incorporated or not. So, from the definitions given by the very famous thinkers, we can conclude that any person who is vested with some kind of rights or is capable of having certain duties is said to be a legal personality. There are two kinds of legal persons. There are two kinds of person. Number one is legal person, and second is natural person. Coming to explanation of natural persons, a natural person is a human being possessing natural personality. According to Holland, a natural person is a human being as is regarded by the law as capable of rights and duties. On the other hand, legal persons which are also known as juristic or fictitious or artificial persons are a legal person has a real existence, but its personality is fictitious. A fictitious thing is that which does not exist in fact, but which is deemed to exist in the eye of law. Example, company or corporation or idol. Coming to the next topic, that is legal status of unborn person. A child who is still in the womb of the mother is considered not technically a legal person because such person is not born yet. But by legal fiction, the fetus gets some legal rights and the society has a certain duty to perform towards such unborn. There are certain laws in India which advocate an unborn child as a person and grant him certain rights, some of which are as follows. Section 112 to Section 116 of the Indian Penal Code deals with the law relating to abortion. The Medical Termination of Pregnancy Act lays down various laws and procedures to be followed in order to get a child aborted. Next is the legal status of a minor. Minors are legal subjects and their position in a legal and social society should be at the heart of the legal system. Their key characteristics is that they are unable to perform legal connections on their own terms. So, in the society, a minor is not considered as a legal person because he or she is not capable of having any duties fulfilled. Due to its incapacity, whether it's mental or physical, a minor is not held responsible for any act, and even if he is responsible, he shall not be answerable to anyone. In the case of a company, a minor can, in the case of a partnership, a minor can be a partner, but he will not be responsible to bear any kind of loss. Similarly, in the law of contract, a minor is not being bound by the contract and he is given a free choice and is given freedom not to pay any sort of damage if he has been a party to a contract. This is due to their lack of total capacity as they enter essential legal relationships through their parents or someone who may replace their place. Next is the legal status of lunatic and drunken person. Status of lunatic and drunken persons have some special position. They are natural persons and have legal identity. If at the time of entering into a contract, lunatic or drunken person is incapable of understanding the nature of a contract, then they are considered to be incapable of entering into a contract. Basically, under the Indian law, any person who is having a sense of responsibility, who is capable of possessing his mental capacity, is said to be a sane person. Whereas lunatic or drunken persons are usually deprived of their mental capacity to take any decision. They are not aware of any right or duty or aware of the nature of the act they are doing. Hence, they are not given any any status, but they are given a legal status of being a lunatic or drunken person. Legal status of dead person. Dead persons have no legal personality, hence cannot sue and be sued. Dead men are no longer persons in the eye of law, whereas legal personality of a person dies when the person is no more. So basically, a dead person is not presumed to be a person at all in the general parlance. But when it comes to from the jurisprudence aspect, a dead person is considered as is given a legal status because there are few distinct features which need to be preserved after his death. Number one is his body, then its reputation, and third is his property. Dead persons do not remain the owner of their property until their successors enter upon their inheritance. When a person dies, leaving his will, his property is distributed according to the will. Law recognizes and takes into account after the death of the person of his desire and interest when alive. There are three things in respect of which the anxieties of a living man extend even after his death. Number one is his body, his reputation, and his property. Coming to his bodily section, a living person is interested in the treatment to be given to his own body. A person is interested in a decent funeral and a good burial. Criminal law secures a decent burial for all dead persons, and violation of a grave is a criminal offense. So, in the recent times, there have been cases where an offense has been committed against a dead person. So, under this provision, the section has been formulated, and by doing any offense against a person who is dead comes into the same category of any person living. His reputation. Everyone is interested in maintaining reputation even after death. The reputation of a dead person receives some degree of protection from the criminal law. Defamation suit can be filed for loss of reputation of a dead person. If the person is having an if a publication of any person does any attack through any means on a person is a matter of fact, this right in reality not that for the dead person but for his living descendants. We can conclude that this protection of reputation of any dead person is done for the sake of the protection of the reputation of his living descendants. Thirdly, his property and estate. A man is dead, but his hand may continue to regulate and determine the enjoyment of the property he owned while he was alive. William versus William, 33 Bombay 122. In this case, court held that a person during his lifetime cannot make a will disposing of his body, example, giving his brain, bones, etc. to the museum or giving any part of his dead body to the medical college. But the trend has changed today and it has been legal to donate one's eye or part of his body after his death. Legal status of animals. The law does not recognize beasts or lower animals as for persons because they are merely things and have no natural or legal rights. Salmon regarded them more objects of a legal right and duties, but never subject of them. Animals are not capable of having rights and duties, and hence they are not a legal person. In the case of Animal Welfare Board of India versus A. Nagraj, 1949, Honorable Supreme Court observed that Article 21 of the Constitution safeguards the right of humans and explained that it includes all forms of life, including animal lives, and all the animals have honor or dignity. Next, legal status of an idol. It has been judicially held that idol is a juristic person, and as it can hold property, its position is, however, like that of a minor and a priest, that is the pujari, act as a guardian to look after its maintenance. So, in the case of any temple or mosque, the people are having a sense of respect or a sense of or follow a religion, there the idol is not a human. The idol is not having a physical. The idol is not in a physical form. But in the case of jurisprudence, an idol is given a legal status and its position, however, like that for minor. Basically, a pujari acts as a guardian to look after its interests. Honorable Supreme Court in Yogendra Naskar versus Commissioner of Income Tax in the year 1969 held that an idol is a juristic person capable of holding property and of being taxed to Shibai, entrusted with the possession and management of his property. An idol can be treated as a unit of assessment for assessing its liability under the Income Tax Act. So basically, in this case, it was held that idol is a juristic person who is capable of holding any property. And such property is managed by a person who is Shibai, that is the manager of the temple, or any religious property, who is interested with the possession and management of the property. An idol can be treated as a unit for income tax provisions. Another disputed matter is the legal status of mosque. Regarding the legal personality of mosque, the courts have expressed conflicting views. In the case of Maula Baksh versus Hafizuddin, 1925, the High Court of Lahore held that a mosque was a juristic person capable of being sued. But in the case of Masjid Shahid Ganj versus Shiromani Gurudwara Prabandhak Committee, 1940, the Privacy Council held a contrary view and held that mosques are not artificial persons in the eye of law, and therefore no suit can be brought by or against them. The Privy Council, however, left the question open whether, for any purpose, a mosque can be regarded as a juristic person or not. Come to the one major topic is corporate personality. Legal personality is an artificial creation of law. Entities such as law are capable of being parties to a legal relationship. A natural person is a human being, and a legal persons are artificial persons, such as corporation. Law creates such corporation and gives certain legal rights and duties of a human being. A legal personality is what provides a person or organization rights and responsibility by the law. These days, the concept of legal personality is frequently a part of discussion about the rights or legal responsibility of entities such as corporations that cannot be defined by a single person. There are numerous theories related to the concept of corporate personality. This concept being a very new to the jurisprudential aspect, there are largely main five theories. Number one is fiction theory. This theory says that a personality of a corporation is different from that of its members. Thus, any change in the membership will not affect the existence of the corporation. This theory says that every entity other than humans are having an existence of a corporation for a time being only. This theory considers only humans as as a real personality, whereas any other institution, college, company are given a fictional color of a corporate personality for a very time being. Second theory is concession theory. It is considered with the sovereignty of a state. It presupposes that a corporation as a legal person has great importance because it is recognized by the state or the law. According to it, a juristic person is merely a concession or creation of the state. Third theory is group personality theory. This theory believes that every collective group has a real mind and a real will and a real power of action. So a corporation has a real existence, irrespective of the fact whether it is recognized by the state or not. The fourth theory is the bracket theory or the symbolist theory. It states that the conception of a corporate personality is important and it is an economic device by which we can simplify the task of coordinating legal relationships. Thus, it emphasizes that the law should look behind the entity to discover the real state of affairs. The last is the purpose theory or theory of Webb Vermorgen. It declares that only human beings can be a person and have rights. It also states that a juristic person is no person at all, but merely a subjectless property meant for a particular purpose. There is ownership but no owner. Thus, a juristic person is not constructed by a group of people but based on some object and purpose. Only living things can be the subject matter of rights and duties. So, after the explanation of all these five theories, the students will be able to conclude that why there is a distinction between a human, a naturally born person, or other entities which have been given a corporate color for the working of the society. Again, I would like to do a revision and would state or would begin with the starting. So, a legal personality, as I have stated, begins with a birth. Any personality that has been given to a human begins with a birth and ends with the death of any person. So, whenever a child is born, he is constituted as a person in the eye of law. And when once a person is dead, he stops being a human in the general parlance. But for the sake of his reputation, but for the protection of his reputation, there has been cases and there have been sections in the Indian law which safeguards his interests related to the body, reputation, and property. So, if we connect this topic to the other branches of law, that is with the contract, with the Hindu law, with the IPC, we would find that there are numerous laws who are made for the protection of a person interest. So in Hindu law, a child in womb is considered in existence and he inherits the property if he is born alive. Simultaneously, if a partition takes place among the co-partners, that is something related to the Transfer of Property Act. So if a partition takes place among the co-partners, a share is to be reserved for him. If the share is not reserved and the partition will reopen and a newborn boy would take the same share, which he would have taken if he would have born before the partition. Hence, if a pregnant woman is awarded death sentence, the execution of the sentence shall be postponed till she is delivered of the child. Abortion and child destruction are crimes. Simultaneously, we would see that in the case of IPC, section 112 to 160, it states that a person is not entitled to kill any child in the womb because that is also a crime. The concept behind this provision is this only that a child, even if he is born even he is born, he will be entitled as a person of legal status. Similarly, minors are the legal subjects, and their position in law and social society should be at the heart of the legal system. Their key characteristics is that they are unable to perform legal connections on their own. So, somewhere, why we have not given minor a sense of responsibility because minors are not capable to perform legal connections or legal duties which are invested with them. Hence, in general parlance, a minor is not a human, but the law has given a legal status to the minor, but despite of this fact, a minor shall not be capable of any wrong that has been done by her. So we will find that in the case of Mori Bibi versus Harvardar Ghosh, it has been held that he, being a minor, is not liable to pay any amount and or in other cases it will be held that the guardians shall be held as responsible but not the minor himself. Similarly, dead persons once they are dead are left with no right. But for the sake of his body, his reputation and his property, he have been given certain rights even after his death, which secures the protection of the interests of his living descendants. And in the case of William versus William, we have seen that the court held that a person during his lifetime cannot make a will disposing of his body, example, giving his brain, bones to the museum or giving any part of his dead body to the medical college. But in the recent time, we have seen that many people have donated or many people wish to donate their organs to the charity for the sake of transplant, and this criteria is no more valid in the current time. We would discuss the legal status of animals because, in general, the animals are not considered as humans. But in the recent development, animals, rivers, waters, all the natural bodies are given the status of legal person because, as a society and we as humans, when we live in an economy, we need to have the progress and protection of every entity living together. So animals are given the equal rights, and the Supreme Court in the Animal Welfare Board of India was in Nagraj 1949 held that Article 21 of the Constitution of India safeguards the right of all humans and protect their lives. Their definition of the word life is expanded and explained that it includes all forms of life, including animal lives, and all the animals have honor and dignity. Similarly, we have discussed the legal status of idol and the legal status of mosque, which have been very controversial. But in the current times, idol is considered as a legal person, whereas a mosque is not considered as a legal person. We have discussed corporate personality theory. Corporate personality is something, a very new concept, and in the case of Salmon versus Salmon, it has been held that every member of a corporate personality is distinct from a corporation. Even if a company remains or not, even if all the members move away or the company get wind up or the members get insolvent, the company will continue. We have discussed in this lecture five theories. Number one was fiction theory. Second was concession theory. The another was group personality theory. The fourth was the bracket theory or the symbolist theory, and the last one was the purpose theory. So after reading all these theories, we can assume that jurisprudence is a very pragmatic subject, and not only humans are given the right to have any duty or exercise their freedom, but other entities also have been given the same rights by these five theories. With after explaining every topic in detail and after knowing all these theories, I would I presume that it has been made clear about the concept of corporate personality, legal status of dead person, living person, unborn person, and the all the theories of the corporate personality. In this, for the preparation of this lecture, I have used the references such as number one is Dr. N.V. Pranjapan, Studies in Jurisprudence and Legal Theory, and second is Dr. V.D. Mahajan, Jurisprudence and Legal Theory. I assume that all these slides have been very useful to every student of law. Thank you.